Welcome to Founders Friday. My name is attorney Enrico Schaefer. I'm a litigation attorney specializing in technology and founder representation at the law firm Traverse Legal. We are a national law firm handling clients across the globe on complex litigation, intellectual property, and tech matters. Today we're going to be talking about something that's going to be a little bit unusual, but for founders of companies, you are the ones that have to make really strategic decisions about a number of different things, including litigation. Sometimes litigation becomes inevitable. It's rarely something that companies and founders are looking to become involved in, but it can be something that comes across the path and you have to deal with it. So today I want to talk a little bit about how to deal with the prospect of litigation from the founder's point of view, from the person that owns the company, that started the company, that has all of the sweat equity into the company. Now, litigation is something to be avoided if at all possible in most circumstances. It's costly, it's expensive, it takes a tremendous amount of resources in order to pursue. If you're trying to make a decision as to whether or not to be a plaintiff in litigation, that's an easier position to be in because you get to choose whether or not to file that complaint or not. If you are the target of litigation as a defendant, then choice can sometimes be removed, right? Because you are getting sued, and at that point you have no choice but to step up and deal with the situation. Now, litigation is very much an art. It is much more than filing paper in court, asserting positions. It is, at its core, an exercise in strategy. There are 1,000 ways to skin the litigation cat, and your choice of counsel is going to be dependent in part on the strategy that you look to pursue. Now, some attorneys just simply go through the motions and there's litigation, you respond to the complaint, you go through the paperwork, you deal with the court filing dates. What I find is missing in all too many cases is an initial documented strategy. That's where you take a look at the entire playing field, both your claims, the leverage that you can assert, the leverage against you. You take a look at the other side. You do an analysis of what kind of company they are, whether or not they're overly litigious or litigation adverse. And you develop around the facts and the parties and the people involved a strategy. Are you looking for money? Are you looking to get some non-financial consideration? Are you looking to litigate for a long time? Are you looking to get in and out quickly? Whatever your goals are, those should be spelled out and documented at the very beginning of the lawsuit. Because a good attorney will not simply go through the motions. A good attorney in litigation is going to accomplish your goals. So you list your goals, and they're different for every single company. You list your goals and then you prioritize them, 1 through 5. What is the most important thing? What is the second most important thing? Once you've done that, a good attorney can actually use all of that attorney's brain power, experience, the law and the facts and the legal and non-legal leverage, and then spin that into a result. If you do not document your strategy, then you will not likely achieve your goals. I often say that the practice of law, and especially litigation, is like a 5-lane highway. And an attorney can, on an hourly billing basis, right, can drift from shoulder to shoulder, and they're still on the highway, but are they really getting you where you want to go? It's all legitimate billing from here to here, but what you really want is a focused. Pick a lane and stick to that lane. If there's something that changes in the course of the case, you can choose strategically and after discussion to change lanes. But you want a very narrow focus, a very strategic focus to your case. The third thing I want to talk about is the team that you put in place. The team is going to include both the litigation attorneys and the internal resources you provide in order to get the information and make the decisions. The team you put together is critical. Now, you're going to have one person in charge, and that typically is going to be the lead or first chair trial attorney. And this is really important. You cannot do litigation by consensus. It doesn't work. And the reason it doesn't work is this. At every juncture, there are dozens and dozens of ways that an attorney can handle a phone call from the other attorney, can handle whether to file a particular document with the court and what is the primary message of that document. And at every given point in the case, there are all these nuanced decisions that need to be made. And those are going to come from your trial attorney's instincts, from their experience, from their gut sometimes. And what you don't want is to lose that experience, lose that nuance that that attorney brings to the table because there's all these different people, all these different cooks in the kitchen. That will be counterproductive. So make sure that your lead trial attorney, everyone on the team understands they're the final decision maker. Sometimes you just don't have time to debate what happens next. The next thing I want to talk about, which is the fourth thing, so we talk about strategy, we talk about the 5-lane highway, we talk about team. The fourth thing is emotions. There is no question that litigation can be extremely emotional because of what's at stake, because people are saying things, people are in many instances lying, and what you want to avoid is to have an emotional response to a particular situation. You want to make sure that you're taking a look at it from a business, from a founder's point of view. Does this make sense? What's the return on investment? What am I achieving? What were those goals that I set forth, documented, and prioritized? Does this advance me towards those goals? If you want an outcome, everything should be filtered through that outcome. So leave your emotions on the table. A good trial attorney handling your litigation will check your emotions at every point. Will make you put those emotions to the side and deal with things from a strategic or business point of view. The fifth and last thing I want to talk about is this notion that litigation is going to the courthouse and filing paper, and that it's a simple process. Every founder of every company, whether you're a startup company or a founder of a mid-tier company that's got that $1 to $3 million in revenue, or a founder of a company that's hitting $100,000 in annual gross revenue and more. You need to understand this. Litigation is complex, it's variable, it's hard to predict, and it is much more than filing paper. The resources that will be required from your company in terms of time, in terms of distraction, in terms of emotion, is going to be infinitesimally higher than you could ever anticipate. So a lot of times founders and company owners refer to this as the soft cost of a particular matter. The soft cost of litigation is extremely high. So all that time you're going to be spending on the litigation is time you're not going to be pursuing your business. Is going to be time that you're not being strategic about what comes next in your business. So you have to account for that, and you have to be accepting of the fact that if you do not bring the resources that your litigation attorney requires to the table, if you do not get your lawyer who's handling the case the information they need, if the information isn't absolutely accurate in every way, then you should not be bringing that litigation case. You have to understand resources are important, and you, the founder, the company, are going to be a very important resource in order to win the case. My name is trial attorney Enrico Schaefer, and that's what we've got for today on Founders Friday. Good luck, stay safe, and if you can, stay out of court.